The title of our presentation is Never Settle for Mediocrity. What do I mean by that? Well, our team does primarily medical malpractice cases, and in this environment, you just can't prove your case. If you prove your case and that's all you do, you're going to lose today. So what do you need to win? Well, you need something powerful. You need something strong. What I'm going to show you are a few things from very recent cases, and I'm going to show you some of the tools that we've been able to develop in two ways. Number one, with tools to demonstrate concepts that are difficult to the jury. And two, when you're able to do it, you can use the defendant's own testimony to prove your case. And here's some of the ways we've been able to do it. That man is Jim Gaffigan with his wife. In 2008, he went to Jeff and he had surgery that should have been a very routine procedure. He had a small tumor in his pituitary gland. That's behind the nose and in front of the brain. You don't go through the brain to get the tumor out. You go in the nose, you take out the tumor with a little tool that you'll get to see in just a moment on the screen, and you remove it. So he had the procedure done in 2008 by a very, very well-credentialed expert, the head of the department, and he had a horrible, horrible complication, massive bleeding, and half of his body was paralyzed. So it sounds like a case. It sounds like something that shouldn't happen. And here's the first critical piece of evidence. This is the surgical pathology report, and it showed fragments of anterior hypophysis and neurohypophysis and fragments of gray and white matter. What does that mean? That means brain matter ended up in the pathology sample. Well, we don't think that's supposed to happen. We had great experts who say it's not supposed to happen, so we love the case. But this guy had a really compelling explanation for what he says happened, and here's what it was. He said, Mr. Weinstock, you're misunderstanding this. It's not like this pituitary tumor is a marble that you just pluck and it comes right out. It grows against the brain. It's large. It's not as simple as plucking it out by itself because sometimes it adheres to the brain. There are blood vessels connecting the tumor to the brain. And so you're tugging here, you're pulling there. Sometimes, unfortunately, this happens. And he said, I've had it happen in my own experience over the years. And he just told a story that sounded believable. So I went back to my office, I talked to my experts, and with a lot of work, we figured out how we could sort of dispel this story, expose what I call the big lie, and it was with an animation. All right, what you're looking at now is Jim Gaffigan's actual preoperative MRI. But right now, we're just orienting the jury to the anatomy that's important in this case. So we've inserted the MRI against the anatomic drawing, and we're showing them what it really means. This is the proper operative field. And you can see if this procedure is done correctly, this is a surgical curette. It goes in through the nose into what's called the capsule that encloses the pituitary tumor in this case, and that's brain matter all around it. The injury in this case was behind the brain. So we're showing in green the operative field where our experts say the standard of care permitted the doctor to be. What we needed to show the jury is the defendant's explanation of how all this tissue is grown together and it's all in contact and it shares a common blood supply just isn't anatomically true. The injury in this case occurred to the basilar perforating arteries, which you can see in the upper right-hand region, the third cranial nerve, and then there were chunks of gray matter and white matter that got surgically removed. He instrumented the brain. Now we rotate this around, and you can see, and the jury can see, and the mediator could see how clear it is that you can't possibly do what he did if you remain where you're supposed to remain. Now, the size of this is obviously different. The brain's not really that big, but it's more than 1 centimeter separating the pituitary from the brain. And our theory of the case is he did just what you're seeing right now. He put the surgical curette further than the surgical field permitted it to be. And now we're going to sort of wrap it all up together and integrate the post-operative MRI. So what you'll see is where the injury ended up being, and afterwards we're going to show you a side-by-side. And in a nutshell, we are now using what I think was a pretty creative, and I assure you a very effective way of showing the jury that the injury shown on the right side could only reasonably be caused if what we say happened is really what happened. But this wasn't enough, I didn't think. What I'm going to show you now is how we were able to actually take the deposition testimony of the defendant doctor and work it into our case. Now, this is a different drawing that comes out of a book, and I had Dr. O'Rourke mark this up and give me the standard of care during his deposition. And here's what that testimony looked like. You've drawn on O'Rourke for a blue arrow showing the direction of entry, and then you've drawn a circle showing essentially where the tumor was and your intended surgical field, correct?
That's correct.
Am I correct that it would have been below the standard of care for you to have extended surgical instruments in the direction of the blue arrow through the circled area and into the brain?
It would have been unacceptable standard of care. That did not occur.
Did not occur, he says. Well, now we go back in the presentation to the preoperative MRI shown next to his own drawing, and what we do is we take that proper operative field, which is in complete agreement with Dr. O'Rourke's testimony, and we show it side by side with the postoperative MRI. So folks, what I was intending to do here, and I think it was very effective, is use the defendant's own admission on what the standard of care is with anatomy, because anatomy doesn't lie. Sometimes doctors do. Sometimes they give testimony that just doesn't make sense and can't be defended. But when you can use anatomy that's honest and is in a textbook and have the doctor explain it and then make your expert show the jury how it's relevant to your case and have everybody agree on the standard of care, you end up, in this case, with a very nice settlement that occurred at the mediation about 2 weeks ago. So what I think we're able to do is to expose what I call the big lie using the defendant's own testimony.